Picture this. You're running a completely mundane errand. You walk into a local convenience store, grab a few items, head to the checkout, and pay. It's something we do all the time, right? But what if I told you that back in 1997, in a newly democratic South Africa, a few everyday transactions just like that at local 7-Eleven stores sparked a massive constitutional battle? Today, in this explainer, we're diving into a fascinating piece of legal history where the simple act of buying a bottle of wine or a cider tested the absolute limits of economic and religious freedoms under South Africa's interim constitution. Here's our roadmap for today. We're going to start with the initial crimes themselves, and then we'll unpack the really profound democratic principles they ended up challenging. All right, Section 1, the 7-Eleven liquor cases. Let's look at how 3 totally normal convenience store employees found themselves right in the crosshairs of the law and ultimately at the center of a landmark Supreme Court case. So our story centers around 3 7-Eleven employees, Rebecca Lawrence, Rodney Neagle, and Magdalena Solberg. They were each charged with breaking seemingly simple provisions of the Liquor Act of 1989. The infractions were really straightforward. You had Lawrence, who sold wine on a weekday, but after closing hours. Then there was Neagle, who sold beer and cider, even though the store's grocer license only actually allowed for the sale of table wine. And finally, Solberg, who sold wine on a Sunday, which was a legally designated closed day. Now here is where it gets interesting. Instead of just paying a fine or disputing the facts, they took a much bolder route. They challenged the constitutional validity of the laws themselves. I mean, look at this question. Is selling wine on a Sunday a constitutional crisis? On the surface, it sounds kind of absurd. But these weren't just petty crimes. These were direct challenges testing the freshly drafted interim constitution. The appellants were asking some really fundamental questions about just how much control the state should actually have over what citizens buy and sell, and exactly when they're allowed to do it. Moving into Section 2, we hit the first massive constitutional question triggered by these cases. Exactly how far do our economic freedoms go? To defend themselves, the employees pointed straight to Section 26 of the interim constitution. This section states that every person has the right freely to engage in economic activity and pursue a livelihood. Their argument was that the Liquor Act's strict rules on trading hours and its mandates on exactly which products a grocer could sell directly infringed on this constitutionally protected right. Basically, they believed the market should just be free. So, we've got a classic clash of perspectives here. On one side, you have the appellants demanding an unconstrained right to transact business freely. They felt that telling them when they could sell wine or stopping them from selling beer alongside wine was just an irrational infringement on their economic liberty. But on the other side, the state argued it had a very rational basis to curtail alcohol consumption. The government's stance was, look, liquor is a potentially harmful substance. It's universally linked to crime and public health issues, which means the state has a legitimate, unavoidable duty to regulate its supply through a strict licensing system. Enter Judge Chaskalson, the president of the Constitutional Court. He hit the nail on the head when he stated that a shopkeeper cannot claim to have an unconstrained right to transact business whenever one wishes. His point was that in a modern, democratic society, economic freedom doesn't just mean a free-for-all. You can't use economic freedom to justify, say, selling unregulated drugs or just totally ignoring zoning laws. Economic freedom absolutely exists, but it exists within a regulated system designed to protect the public. Okay, Section 3. Now that we've established that economic rights have boundaries, let's zero in specifically on Magdalena Solberg's case, because it really sets the stage for a much deeper debate. Remember, Solberg was charged for selling wine on a Sunday. Under the Liquor Act, grocers were banned from selling wine on highly specific, closed days. Look at this list: Sundays, Good Friday, and Christmas Day. Notice a pattern there? By looking at these specific days, it becomes immediately clear why a totally different and deeply philosophical constitutional argument was brought before the court. These aren't just random days of the week, right? And that brings us directly to Section 4, freedom of religion. Was this Sunday ban just a practical secular rule, or was it sectarian coercion? Solberg's legal team brought Section 14 into the spotlight. This is the right to freedom of conscience, religion, thought, belief, and opinion. They argued that the Liquor Act's definition of closed days explicitly targeted the Christian Sabbath and Christian holy days. By legally enforcing these specific days as off-limits for liquor sales, they claimed the state was unconstitutionally forcing a sectarian Christian conception of rest onto all citizens, regardless of what they personally believed. It's a really fascinating debate when you break it down. The appellants argued that picking Sundays, Good Friday, and Christmas was a clear legislative endorsement of Christianity, essentially coercing citizens to observe those holy days. The state countered that by saying, well, yes, these days have historical religious roots, but Sunday in modern South Africa has just become a secular day of rest. It's simply a practical way to maintain social order and give everyone a unified break. Judge Chaskalson actually sided with the state's perspective here. He ruled that the ban didn't actually coerce anyone into worship. As he noted, Sundays have acquired a secular as well as a religious character. It's just the most common day of the week people don't work. The law wasn't forcing the 7-Eleven to close their doors. They were still open, still selling groceries. It was just curtailing the sale of a regulated substance on a day when the vast majority of the population was off the clock. For him, the connection between the Christian religion and the liquor restriction was just too tenuous to be a real infringement of religious freedom. But hold on, because this wasn't a unanimous view. Judge O'Regan offered this incredibly powerful dissenting viewpoint. She looked at it and pointed out that out of 12 statutory public holidays, the state specifically cherry-picked the 2 with direct Christian foundations, plus Sundays, to restrict alcohol. She argued that the inevitable effect of choosing those exact days was to give a legislative endorsement to Christianity, favoring one religion over others. In her view, true freedom of religion in a diverse society means the government has to act even-handedly, and this law failed that test. Section 5. The final verdict. So after all these heavy, deeply nuanced legal and philosophical arguments, where did the highest court in the land actually land? Well, ultimately, the Constitutional Court dismissed the appeals of Lawrence, Nagel, and Solberg. The majority decided that the state absolutely had a rational basis to regulate the liquor trade to protect public health and safety. The restrictions on trading hours, the specific types of liquor sold in grocery stores, and that prohibition of sales on Sundays were all upheld. They were deemed valid exercises of government power that did not unconstitutionally violate the rights to economic activity or freedom of religion. So, the conviction stood. So, what should you actually take away from this explainer? Why does this all matter? Well, this case was never really just about a few bottles of wine or cider at a 7-Eleven. It matters because it defined the boundaries of economic freedom in a brand new democracy. It proved that free enterprise still has to operate within boundaries meant to protect society as a whole. It perfectly illustrates that delicate balancing act between your individual liberty and the collective good. And finally, it shows just how incredibly complex it is to separate historical religious practices from modern secular laws when you're living in a highly diverse society. I want to leave you with this final provocative thought to consider the next time you're just running a mundane errand at the grocery store. When you reach for an item on the shelf, remember that there is an invisible web of laws, values, and constitutional compromises dictating exactly what is sitting there and exactly when you are allowed to buy it. How should a democracy balance your freedom to buy and sell with the health and values of the public? Think about that. Thanks for joining me for this explainer, and as always, keep questioning the everyday rules around you.